Hello, and welcome to another episode of Cause for Action. I'm Paige Faulk, a Senior Vice President at the U.S. Chamber of Commerce Institute for Legal Reform. If you've ever voted in a state election, odds are you have voted for a state attorney general, unless you live in one of the 7 states that appoint their attorney general. But you may still wonder what exactly this elected position does. In this episode of Cause for Action, we will touch base on what state attorney generals do and the critical role they play in not only state, but national policy. I am pleased today to have with us Rob McKenna. Rob is a former Washington State Attorney General and president of the National Association of Attorneys General. He is an accomplished in all areas of the law, public policy, appellate law, and investigations. And he's currently a partner in Orrick's Seattle and Washington, D.C. offices, where he leads the state attorney general team in the firm's public policy group. Really excited to have Rob today, but before I get into asking Rob some questions, I wanted to throw out a little trivia. Just a few weeks ago, Jeopardy had as a question, who was the first attorney general? And they were asking about the first attorney general of the United States. The answer, who is Edmund Randolph? Well, interestingly, Edmund Randolph also served as the first attorney general of Virginia, even before the National Attorney General was created by Congress. So with that and a little history, and interestingly, before that, Edmund Randolph's father was serving the king during colonial times. And that's actually where the state attorney general and the U.S. attorney general derive from. They served as the king's lawyer. But now, to get us to modern times, Rob, can you tell our listeners and our viewers out there what you believe the main job of the state attorney general is?
Well, first of all, Paige, thank you so much for having me on your podcast today. I really appreciate the opportunity. The attorney general's first and foremost responsibility is to oversee all the legal services provided to their state. It's in some ways the least visible part of the AG's job, but also one of the most important, since the states rely on the AG office to represent them in court, sometimes in criminal proceedings, and also to defend the state against lawsuits for torts, for example. The second and much more visible part of what the AG does is to represent the interests of consumers in their state. And they do that by enforcing their state's Consumer Protection Act and also the state's antitrust laws, the laws protecting economic competition. There's a third role as well, which depends a lot on which state you're talking about, but it has to do with handling criminal trials. In most states, AGs don't have original criminal jurisdiction, and so they only handle criminal cases that the local prosecutors ask them to take on. But in a handful of states, like Alaska, for example, the Attorney General's office is part of a Department of Justice, and they actually provide all of the criminal prosecution services for the entire state. But again, that's only in a handful of states.
Interestingly, can you tell us a little bit more about the civil side of state attorney general offices?
Sure. So you see the civil side in 2 areas. One, again, is to defend the state in civil actions or to represent the state if the state is the plaintiff in a civil action, defending the state's interests, let's say over a property issue or enforcing an environmental law or regulation. But, again, there's a much more visible part of the AG's office in terms of civil actions, and that's enforcing the state's Consumer Protection Act and antitrust laws. We see a lot of activity in the AG offices in pursuing violations of Consumer Protection Acts, which prohibit unfair or deceptive acts or practices by companies, by businesses. And those can be very high profile, such as the tobacco litigation, or they can be much lower key, like going after a company that hasn't been treating its customers right, isn't giving refunds promptly or something like that. So those kinds of cases run the gamut. Most of them don't result in litigation because most companies simply want to get it right. They want happy customers. They don't want to be in trouble with the AG. And so, when I was Attorney General, we were able to resolve the vast majority of those cases pretty promptly because we had cooperating and cooperative companies we were dealing with. But there are also the big cases that can result in months or even years of litigation, often on a multi-state basis. In other words, AGs collaborating on the investigation and then several states bringing a lawsuit to go after the target.
Very interesting. So give us a little bit more about how a company in a state might interact with the state attorney general, and then also, me as a citizen of a state living in Virginia, for example.
Well, starting with citizens of the Commonwealth or residents of any state, you'll often have consumers filing consumer protection complaints with the Attorney General's office. Most AG offices run some sort of consumer protection center that will be an intake center for complaints that consumers have about a car dealer or a contractor or a travel agent or something like that. And typically what the AG office will do in those cases is contact the company, alert them that or notify them that a consumer has filed a complaint, and encourage the company and the consumer to work it out. Other times, consumer complaints result in significant AG investigations of a company's practices. One key piece of advice I have for companies that I've been giving them since I was in office, and I continue to give them as clients, is to act promptly and swiftly on consumer complaints. Try to resolve them at the consumer level so that it doesn't turn into an AG investigation, so you don't end up seeing a subpoena after originally being notified about the complaint. So companies will most frequently interact with AG offices in those routine cases where an AG office notifies them that there's been a consumer complaint and encourages them to resolve it. And then, at a more complicated level, we'll interact with the AG office if the AG decides to conduct an investigation, issues a civil investigative demand or a subpoena, or even engages in litigation.
Interesting. How do the state attorneys general collaborate together on issues?
This is a very important point about the state AGs. They work together more often on a wider range of issues than any other state elected officials in the country. They get together at a staff level and look at trending consumer protection issues. They collaborate to go after Medicaid fraud through each office's Medicaid fraud control unit, which is funded partly by the federal government. They collaborate on antitrust issues. In fact, the National Association of Attorneys General, or NAG as we fondly call it, came together originally over concerns with the Standard Oil Trust. They met in St. Louis in 1907 to decide how they could work together to investigate the Standard Oil Trust and to try to break it up, because they had been working on antitrust issues longer than the federal government had, just as we had we had state consumer protection laws before there was a federal consumer protection law, the FTC Act. There were state antitrust laws years before the Clayton Act or Sherman Act were passed. The states were already enforcing against anti-competitive practices. So these multi-state actions have a long history. They can result in very, very big outcomes, such as the Tobacco Master Settlement Agreement, which really reshaped the landscape for cigarette smoking in this country. We're seeing it right now with the opioids cases. And there are lots and lots of other types of cases that the public isn't as aware of, where the AGs are working together, sometimes just a handful of states, other times all of the states working together to investigate and sometimes to litigate with companies.
You've talked about the impact of these issues, really they're national issues that the state attorneys general are addressing. Certainly they play a major role in their states, but can you expand more on the impact on federal policy?
Absolutely. The states can and do have a significant impact on federal policy. I'll give you an example that I dealt with when I came into office in Washington State in January of 2005. the office was already part of a 5-state lawsuit against the Federal Environmental Protection Agency, suing the EPA, arguing that the EPA was required to regulate greenhouse gas emissions under the Clean Air Act, even though the Clean Air Act doesn't expressly refer to greenhouse gases like carbon dioxide. That case went up to the Supreme Court while I was Washington's Attorney General, and the Supreme Court ruled 5-4 that the Clean Air Act does encompass greenhouse gas regulation, and that obviously has resulted in a lot of changes in this country because it gives the federal government a pretty big hammer to regulate greenhouse gases in the effort to control climate change. We also see, other kinds of actions by the AGs that attempt to shape or enforce or interpret federal law, but they can also, just weigh in with Congress on an issue. An example I was involved with had to do with the law and the Communications Decency Act, a federal statute regulating the internet, and Section 230 of that act. We were concerned that Section 230 was being used as a shield by companies like Backpage.com to shield themselves from liability for facilitating trafficking of young girls. And we worked very hard to persuade the Congress to reform Section 230 to carve out human trafficking from the Section 230 shield, and ultimately it's exactly what Congress did. And you'll see throughout the year the AGs weighing in groups of a dozen or 2 dozen or 3 dozen or more, weighing in on federal policy. For example, the American Bankers Association, other state and national banking associations have been pushing for the Safe Banking Act to allow banking for cannabis-related businesses. And the AGs sent in a letter with more than 2/3 of them supporting that change in the law to allow safe banking. So they'll weigh in at a policy level in Congress, but the most visible and in some ways most impactful thing that AGs do with regard to federal policy is in the courts. And we see that time and again where they are suing, and sometimes against each other, right? You get groups of AGs on both sides of an issue, like the Obama Clean Power Plan, for example, or the Waters of the United States law. And you can have AGs on opposite sides of the issue, but they can be very, very active in trying to influence how those laws are interpreted and enforced.
Yeah. What you see a lot of that in the news. Is there anything of late of interesting that the state AGs are doing related to the federal government and the courts?
I think that right now the 2 areas that are getting a lot of attention. One of them continues to be around environmental laws and regulations, and so you see continuing litigation over the federal government's policies on the environment. Sometimes AGs are suing to block a federal executive order. Sometimes they're suing to prevent it from being rolled back by the new administration. You continue to see fights over elements of the Clean Power Plan and what the federal government's reach is in regulating coal-fired plants, for example. So that's a big area. Another area that you've seen a lot in the news is over immigration. So you have AGs. First of all, you had AGs suing the Trump administration over its actions regarding immigration. For example, suing to overturn the Muslim travel ban. Then under the Biden administration, you see AGs suing particularly states along the southern border to prevent the Biden administration from rolling back some of the Trump-era immigration reforms and protections, that the Biden administration would like to overturn, but that these AGs believe cannot be overturned without going through the proper process under the Federal Administrative Procedure Act. So, immigration and border issues are another really high-profile area where the AGs have been quite active.
Thank you. I want to turn now to some hot topics that are of particular interest to the business community. At the U.S. Chamber of Commerce Institute for Legal Reform, we have been very focused on bringing transparency to the hiring of outside contingency fee counsel by state attorneys general. So I want to talk to you a little bit about that topic. Can you explain a little bit to the audience how the contingency fee process works, and how they are being used by state AGs.
Contingent fee lawyers, of course, take on cases in which they don't receive an upfront fee, and instead they receive 30% or sometimes more of the recovery of the award in that case. So it's a very common model for private class actions, for example, or other kinds of private litigation. But we have seen more and more use of outside counsel on a contingent fee basis in cases brought by state attorneys general over the years. The biggest single instance of that would have been the tobacco litigation. The plaintiffs' firms were going after the tobacco companies for years, not very successfully. But then when the AG started suing and investigating tobacco companies for misleading the public about the health effects of tobacco, they teamed up with these outside contingent fee counsel firms, because the AG offices in the handful of states that started those suits, including my own state under my predecessor, Attorney General Gregoire, they didn't have the resources to mount a case of that magnitude. In fact, Attorney General Gregoire went to the state legislature in Washington and asked for funding to prosecute that case, was turned down, and then went out and signed up a couple of outside law firms on a contingent fee basis. And those firms in our state and nationally, and along with other firms, ended up collecting fees in the billions and billions of dollars, because that was a more than $240 billion settlement that was ultimately reached with the major tobacco companies. We've seen sort of ebbs and flows in the use of contingent fee counsel. When I came into office in 2005, it wasn't that common. We saw them in the lead paint cases, for example. But we've really seen an upswing in the use of contingent fee counsel by the state AGs in more recent years. It became very noticeable in the opioid cases, for example, when former Attorney General Hunter in Oklahoma brought his lawsuit. He used outside firms to do that, and basically bought their lawsuit, if you will, or signed up for it, and that lawsuit resulted in a big judgment against a major pharmaceutical company that was subsequently overturned by the Oklahoma Supreme Court, which disagreed with the public nuisance theory that has become very much in vogue for cases around opioids, for cases around climate change, and for other cases. The plaintiffs' bar is aggressively pushing an expansion of public nuisance theory to a range of applications that no one had ever thought of before. Some state AGs are signing up for those lawsuits, and it's frankly kind of concerning, because the state AGs wield tremendous power, and the plaintiffs' firms will come to them and say, "Hey, let's sue this company or that company, this industry or that industry, and don't worry, Ms. AG or Mr. AG, this isn't going to cost you anything. You just have to lend me the tremendous power of your office." I think that contingency fee counsel should be used very, very rarely, and I think are likely being overused at this point, because it's so tempting for an AG to sign up for what looks like a no-risk lawsuit to sue the major energy companies over climate change, or to sue not just opioid makers, but distributors and pharmacies and everyone else they can think of. It's very tempting, because they can end up raising a lot of money for their states, and it appears to be very low risk for them while it's politically popular. I would rather see legislatures step up and give AGs the resources they need to pursue cases that are really meritorious, so that the risk is really on the state. I mean, that's the way it should work, so that we're not seeing the power of the AG used and overused when they put the risk on private firms and position themselves to try to get the political credit for the outcome.
Yeah, it is problematic, and appreciate your raising some of the concerns with the practice and some of the things that have happened. What's interesting, you mentioned the opioid litigation, and we're seeing now all these cities and counties also suing companies over the same thing, using these trial lawyers on a contingency fee basis. And we understand many of the state attorneys general see problems with that as well. And it'll be very interesting to see, perhaps after all the opioid litigation is finished, if there will be reforms to the use of contingency fee counsel by at least the municipalities, and that state attorneys general would be very supportive of that effort. Because we've seen
you raise a really important point here, Paige, because in the tobacco litigation and settlement, it was just the states that negotiated that important settlement with the tobacco companies. With opioids, you have over 1,700 municipalities that filed lawsuits, and these were almost always cases that were shopped to them, whether it was a little town or a county or even a special purpose district like a hospital district, shopped to them by the plaintiffs' firms. Again, hey, no risk to you. We'll do all the work. You'll get a cut of the recovery. And that has made it harder to settle these cases, much more complex. I've said more than once, I'm not sure we could have gotten to the Tobacco Master Settlement Agreement if there had been thousands of local governments suing as well. It's really a problem, and it's magnified by this enormous growth in the private contingency fee counsel industry, if you will.
Yeah. Moving to another hot topic. It's technology and innovation, but we've also seen the rise of big technology and a change in the regulatory landscape at the federal level. Can you talk, and we're seeing some techlash, we call it, from both sides of the aisle. Can you talk a little bit about the role of state attorneys general in all of this related to big tech?
Well, this goes back to my point about what happened in St. Louis in 1907, which was a long time ago, but was really foundational for the way that AGs interact with the national economy and enforce our competition laws, because they came together to go after the Standard Oil Trust, which they felt had amassed too much power. And it really was a very, very powerful company. And they were also interested in examining other trusts that had been created around that time or before that time as well. So fast forward to current day, and you have some very large technology companies that I think indisputably have enormous power because digital technology generally and the internet specifically have become so incredibly important to our economy and to our daily lives. And attorneys general have become increasingly concerned about the concentration of power in some of those companies, and they have gone after some of them, in some cases with multiple lawsuits, which is what's happening with Google right now, where you have multiple lawsuits brought by groups of state attorneys general who are going after their search business, for example, or their ad business. And that company is in an unenviable position because they are in trouble with Republicans across the spectrum, from left to right, Democratic to Republican. There are more states suing that company now than sued the tobacco companies. There are far more states engaged in that litigation than went after Microsoft over 20 years ago for alleged antitrust violations. So it is really notable. And then the fact that there's not just one but several lawsuits that have been brought on a multi-state basis against that company. It's a challenge for them. There are also investigations that have occurred and lawsuits that have been initiated against some other big tech companies. So what we're seeing here is the attorneys general playing their historical role to protect consumers in part by enforcing our competition laws as they see them, and seeking to limit market power concentration and seeking to restore balance and also to protect consumers. And I don't think that's a trend that's going to end anytime soon. Also, I will point out these lawsuits are in very early days. They're in discovery. They're very complicated, and it is far from certain how they're going to turn out.
Yeah. On that note, I do want to close with two questions for you. One, and you touched on it a little bit earlier, What advice would you give to companies that are dealing with state attorney general issues, whether it be an investigation or some other matter?
Well, first of all, just develop your awareness of the role of the attorney general in the states in which you do business. Be aware of what their current activity levels are. Your general counsel's office can certainly track what's happening in the AG world. There are a lot of us who represent companies in the AG space. I have a dozen clients in the AG space who we keep informed of developments, and we help them with awareness and also outreach when necessary to the AGs. But it's important to understand what their job is and how to avoid problems if at all possible. I already mentioned that one way to do that is to promptly address and resolve consumer complaints so they don't spiral into a larger investigation. A second is to be aware of what the trend lines are in AG enforcement, and if you see them really stepping up their scrutiny of competition, be aware of what your own market position is and whether you have any exposure. A third area to be aware of is that, particularly in the cybersecurity and data privacy space, is the AGs are playing an increasingly prominent regulatory role, starting with the California Consumer Privacy Act and now spreading to a number of other states like Colorado. You see state AGs being assigned the responsibility to write the regulations for consumer data privacy that are to be promulgated under state consumer privacy acts that are being adopted by legislatures. So they are not only going to have an enforcement role like they do under the Consumer Protection Act that has already existed, they're actually in the regulation writing role as well. So they're going to be enforcing regulations they write in their offices. There are opportunities to interact with the AGs and to weigh in on those draft regulations. The Colorado Attorney General, Phil Weiser, has done a very good job of soliciting input on the regulations his office is drafting. So it's important to engage in that way as well. There is no doubt that the attorneys general are more active than ever, are being asked to do more than ever, and as a consequence, have more of an impact than ever on the business community.
Thank you for that. And then my final question, if you had one piece of advice to give to state attorneys general thinking about how to protect consumers while improving the legal climate for businesses, what would you say?
I would say guard your prerogatives carefully and cast a skeptical eye on proposals that are brought to you by outside law firms to file this lawsuit or that lawsuit. It's tempting to jump on board with a case that looks like it's no risk and no cost with potential reward, but I don't think that's an appropriate use of the Attorney General power, frankly. I mean, all AGs understand that they are first and foremost servants of the people, charged with defending and protecting the Constitution and laws of their own states. And that gives them a lot of power, particularly under very broadly written statutes like state consumer protection acts. So I would say, if you think a matter is important enough to go after it, a matter of consumer protection, of competition, or what have you, then put your own resources up. Go to the legislature, get additional resources, but don't deploy that tremendous state power, without putting your own resources on the line to do it.
Well, thank you for that advice. And thank you, everyone, for watching today and listening today to this edition of Cause for Action. Thank you, Rob, for joining us. That was great.
Pleasure, Paige. Thank you.